says Michael Campbell.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Your Honor. Christopher Shemke appearing on behalf of my client, sending to the matter being heard via Zoom. Mr. Campbell, can you please unmute yourself, turn your camera on, and identify yourself, please?
Michael Campbell.
Thank you. Okay, what are we doing on this case?
Your Honor, I had an opportunity to pre-try this matter with Mr. Siller. At this time, my client is prepared to tender a guilty plea to an alternate charge of disturbing the peace. He has been advised of his constitutional rights, prepared to waive his right to his trial, and we are prepared to proceed.
That is correct, Your Honor. I'm going to move to add a count 2 under the Township Code of disturbing the peace. That's section 14-37. It's a misdemeanor, punishable by 90 days and or a fine of $500. If you accept his guilty plea to that added count 2, I've moved to dismiss count 1.
All right, Mr. Campbell, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, sir, again.
Michael Campbell.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace under the Pittsfield Township Ordinance. That is a misdemeanor punishable by up to 90 days in jail and or a $100 fine plus court costs. You understand that, sir?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yeah.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yeah.
You understand you're giving up your right to appeal of right. I'm going to need you to be seated in one spot, sir.
Well, I am at work, but let me sit down. Okay.
All right. You understand that you're giving up your right to appeal of right.
Yeah.
Is that a yes?
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
Were you on probation as of June 9th, 2022?
Yes.
Then I have to advise you that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, that other court could sentence you to the maximum allowable under that other charge. Do you understand that?
I got a question. How could they violate me again when they already violated me for this?
I'm sorry?
They already violated me for this. They reinstated my probation.
Sir, I don't know that. I'm taking a plea. I'm asking you if you're on probation. I have no idea what happened in that other case. So you understand what I'm saying, correct?
Yes, I understand what you're saying, but
Okay, do you still wish to enter this plea, understanding that that's a possibility? I don't know if they violated you or not. I don't know what I don't know how they looked at this case.
I'm telling you they did.
Okay,
So-
you can tell me they did, but I don't know that. That's what I'm telling you. I wasn't there. So I have to advise you of the right that they could violate you on probation. You're telling me one thing. I don't know, but I have to advise you of that. Am I understood?
Can I say something? I'm trying to ask you a question. I'm asking you, can they violate me again?
I don't know if they violated you in the first place, so I can't answer that question. That's what I'm trying to tell you.
Okay.
Do you still wish to enter this plea?
Yes. Guilty.
Has anybody promised you anything other than what's been stated here today on the record to get you to enter this plea?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're guilty of this offense?
yes,
June 9th, 2022, at the location of Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Tell this court what you did that makes you think that you're guilty of disturbing the peace. Counsel, if you want to voir dire, you can voir dire because
Yes, Mr. Campbell, it's my understanding you were a passenger in a vehicle that was pulled over, correct?
yes,
And at some point, the police came and spoke with you and asked you for your name, correct?
yes,
But you did not comply immediately with their orders. Is that accurate?
yes,
And then at some point was found that there was open intox that you had admitted to being in the vehicle and it was poured out, correct?
yes,
Satisfied, Your Honor?
Phil, are you satisfied that the court has complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Anything you want to say before I impose sentence?
Yes, Your Honor. I believe this was just an unfortunate set of circumstances, but it's one that he'll realize not to duplicate in the future. He's gainfully employed. He is currently doing housekeeping. He has a 7-year-old son that he's an active father. He resides with his father, has a strong family support system. I'd respectfully request that he be admonished with costs and fines. Thank you, Judge.
Is there anything you want to say before I impose sentence?
no,
Fines and costs of $250, spend 90 days in jail. When can you get that paid?
what is it? Probably the end of the month or the first next month. The first week of next month.
Call the case, People versus Steven Smith.
Again, James Fifelski on behalf of Mr. Smith. Please state your name. Stephen Smith.
All right.
Your Honor, my client has a script for the Suboxone. He was actually receiving this in custody and they gave him a script when he left. So I can present that to the court.
Does he have a medical marijuana card?
He did, Your Honor. It's my understanding that it was taken into police property or something in one of these arrests. So I would certainly advise him not to consume marijuana.
He's not to
if
be.
he didn't have a.
Looking at the bond conditions, he's not supposed to be using marijuana at all.
Okay.
So
He just, as I told the court earlier, he just got out of custody after about 5.5 months. I think it was 2 weeks ago. He is doing group treatment at Catholic Charities, I believe up in Fenton, Howell. He certainly is aware of his dependence issues and treating those as best he can. I would just ask the court to continue him on bond.
you're gonna need a new order for him.
Okay.
All right.
Yeah,
All right.
I've been on probation with the Department of Corrections, and they've allowed me to smoke marijuana with my
I'm
medical.
telling you what the order reads, and what you can do is you can bring that up. I'm telling you, you cannot.
I understand now.
You can bring that to
I understand.
Judge Kunke's attention if you wish to do so.
I understand.
All right.
So no marijuana unless ordered by Judge Kunke or permitted by Judge Kunke. Got that?
Yep.
All right.
Thank you very much.
I'm preparing a new order consistent with the previous order so that he shouldn't have a problem testing.
Okay.
All right.
And he's gonna, I believe, go back to community corrections right now to get on board with testing.
Thank you.
Thank you, Judge.
Your Honor, we are going to be asking for a brief adjournment on this matter. But with the adjournment, we'd also like to address bond.
That objection, probable cause conference, June 12, 2025, 9 a.m.
Your Honor, as to bond,
Do I have a green sheet?
I'm working on, Your Honor. I have a few of them in my hand. I'm so sorry. As to the bond, Your Honor.
It's going to be adjourned, I see. No need to comment. Go ahead.
Thank you, Your Honor. As, and my pen
Oh, Cannon, really? It's just one of those days.
It went under the lectern, Your Honor. My pen went under the lectern. I'm so sorry. Here we go. As to Mr. Hill, there's the green sheet. Thank you. I'll get it eventually. As to bond, Your Honor, my client has a appointment on June 2nd with the IRS regarding a very serious matter. He is requesting a furlough for that day, just so he can meet with the IRS. He'll come directly back.
Taxes?
So he's this meeting was set.
What it was about.
Well,
And he said taxes.
He said taxes.
Don't worry about it. I don't even know why she asked that
Well,
question.
yes, Your Honor. So it is a tax matter. I didn't want to go too far into.
No, I don't.
Okay.
If he's got the appointment, I just need proof of the appointment. Maybe I'll consider it.
And we can do it in writing.
Yeah, you'd have to do something in writing regarding that.
Perfect. Your Honor, in addition to that, as you know, my client was, the last time he was up, the court did remand him because he was testing positive for substances that he should not be testing positive for. My client at that time was trying to get into a treatment program. Matter of fact, he came from, he was after court, he was supposed to go be scheduled to be screened. My client is asking if he can be released to inpatient treatment, if the court would allow that.
For inpatient treatment, if you send me an order that's stipulated to, certainly I will sign it.
Perfect, Your Honor. Then I'll make it
I'm not going to object to release the info.
perfect. Then, Your Honor, with that, I believe we are all set.
Thank you, Your Honor.
And I'm gonna,
Thank you. At this point, his bond will continue. And I'm not saying, so that we're clear, I'm not saying I grant the furlough, but I need to see information